All right, welcome students to the video lecture series. I am here today again to kind of discuss the concept of jurisdiction that we'll be discussing in the class as well, and you've been reading about. So jurisdiction is, by definition, the power or authority of the court to hear the case. And so as you read through the chapter, you're going to see a lot of stuff on jurisdiction, more than I'm going to talk about in this video, but I wanted to highlight In Personam Jurisdiction that's covered in the course, and I think is a really important topic for business. And so, again, jurisdiction is the power of the court to hear the case and render a decision. And, you know, as you scroll through and read and you go through the outlines, you're going to see just this kind of this conceptual definition of what jurisdiction is. And it's the power to hear the case and render a decision. But contained in that is the power for jurisdiction over individuals, companies or corporations, property that's involved in the suit, and the subject matter of the dispute. And so all these things the court must have jurisdiction over in order to render a decision. Typically, when we talk about property, jurisdiction over the property, we're referring to in rem jurisdiction, which is this concept of jurisdiction over the thing. And so an example of in rem jurisdiction would be a title dispute over real property. So jurisdiction would generally be conferred to the state in which that property is located, the state and county in which that real property, real estate, land, a house, commercial property, whatever, where it's located, right? Because the subject matter of that lawsuit is property, and that property is in that state and county in which the court can take jurisdiction. Alternatively, if it's a dispute over a contract or a product that's defective, or any other lawsuit, personal injury lawsuit related to products or anything like that, then we're talking about this idea of the court exercising jurisdiction over the parties involved, the in personam jurisdiction and the subject matter jurisdiction of that particular court. So jurisdiction over persons is called in personam jurisdiction. So the court can exercise jurisdiction over parties and corporations if they have in personam, personal jurisdiction over that business or the person. And typically when we're talking about in personam jurisdiction, we're talking about where it really matters is when we're talking about when a court tries to pull in a defendant from an out-of-state location. So let's say that you, for example, you own a business in Oregon, and let's say it's a small startup cosmetic business or something where you do facial masks and lotions and other things, right? And you have this business in the state of Oregon. Let's say on the University of Oregon campus, you have a small little shop, and you only sell and advertise locally, right? You're a small little business. You might be a home-based business, and then you might have a little kiosk or something on the campus, and you sell only in that area. That's where you advertise. And let's say that, for example, a student comes to you after a final exam and says, "Oh, I'm stressed out, and I would really like to have a mask or something." And so you sell this individual this refreshing mask that you've created, like that they put this cream mask on their face and let it sit for 10 minutes or whatever and wash it off, right? And you tell them, "Hey, this will be great. It's a perfect for stress release. It'll help." Whatever your sales technique is, right? So this individual buys this mask in Oregon on the campus of the University of Oregon, then goes home for winter break, and when they get home to California, let's say for winter break, they put the mask on, and it injures them. Let's say that they have a reaction to it that's abnormal, and it causes some issues, and they sue you for the damage, the injury that's resulted from the mask, the face mask that you sold them, which from your business in Oregon. So that's kind of, with this kind of factual backdrop, let's analyze the idea of jurisdiction over the person. So we might say then, okay, so the injured party in California then says, okay, well, I'm home now, so I'm going to file a lawsuit in the state in which I reside, right? So that would be the plaintiff filing the lawsuit in the state of California, county in they live. So the plaintiff files the lawsuit and then tries to sue you, serve you, and bring you into California. You're from Oregon. That's where your business is, and that's where you sold it to her. But then they try to sue you in the state of California. This is kind of the classic example where we have to start looking at whether that court has jurisdiction over the individual, the person and the business. Do they have jurisdiction to pull them into California to defend that claim? So that's the question we're going to work with. Okay, so how can states use the long-arm statute to require out-of-state defendants or pull out-of-state defendants into their jurisdiction to defend a claim? So long-arm statutes are just that. They're statutes created in states. And what they try to do is they try to create a situation where the courts in that state can use the long-arm statute to exercise personal jurisdiction over certain out-of-state defendants based on some activity that took place within the state. And so, by way of example, California has a long-arm statute in its California Code of Civil Procedure, Section 41010, and California's jurisdictional statute, long-arm statute, reads, "A court of this state may exercise jurisdiction on any basis not inconsistent with the Constitution of this state or of the United States." So let me read that one more time for you. So California has their long-arm statute states, "A court of this state may exercise jurisdiction on any basis not inconsistent with the Constitution of this state or of the United States." So when you think about that, what does that really say? It's very broad, right? It essentially says, hey, California, you can exercise jurisdiction on any out-of-state defendant as long as it doesn't violate the Constitution, federal Constitution, or state Constitution. So really, what are we talking about when they say the Constitution? And they're really saying due process. That when you're trying to pull someone into a state, then we have to understand that it can't affect the fairness and due process. So essentially, California's long-arm statute says if it's constitutional. So where do we look? So we look to the federal interpretation and constitutionality of jurisdiction over an out-of-state defendant, which is contained in a seminal case called International Shoe Company versus the state of Washington. And the question was, in that case, can a state pull in an out-of-state defendant? And is it constitutional, or does it violate principles of due process that are provided individuals in the Constitution, federal Constitution, and most state constitutions, if not every state constitution? And so the real question is, when you're evaluating the International Shoe factors, and what International Shoe said was that it is not unconstitutional as long as the defendant had sufficient minimum contacts with the forum state such that the exercise of jurisdiction doesn't offend traditional notions of fair play and substantial justice. So the Supreme Court said under International Shoe Company versus State of Washington, does the defendant have sufficient, quote, minimum contacts with the forum state such that the exercise of jurisdiction doesn't offend traditional notions of fair play and substantial justice? So that's the constitutional basis from International Shoe and California, because California statute says jurisdiction can be based really broadly as long as it's constitutional. So we look at the International Shoe case to help us understand what California would allow as far as long-arm statutes and pulling in a defendant from a distant state to fight or defend a claim that's been filed in California. So this minimum contacts test, as I defined it, and as it's stated here in the outline, called corporate contacts or minimum contacts test, sufficient minimum contacts test. So we really need to look at, does the defendant have sufficient minimum contacts with the forum state? And so contained in the international shoe case was some kind of outlines of what it means to have sufficient minimum contacts. And they really kind of generally look at the nature and quantity of the contacts with the forum state and the connection of the cause of action or the lawsuit itself with the interest in the state of protecting individuals within that state. And so then they further this kind of broad analysis of minimum contacts, and then contained in the international shoe case, they said, well, did the defendant by their acts purposely avail themselves of the benefits and privileges of conducting activity in the forum state? Did they have direct sales, marketing, advertising, service in the state? Right? This is direct, purposeful availment of the privileges and benefits of the state. Is there a direct connection between that contact, that purposeful availment and contact, with the cause of action, the lawsuit itself? And then, would it be foreseeable, would the conduct of the defendant, if it's less than continuous and systematic, should it be reasonable or foreseeable that the defendant would be pulled into that state? Because remember, you're going to look at minimum contacts. If it's purposefully availment, it's continuous, it's systematic, they're there all the time, they advertise there, they purposely advertise there, they're looking for business in that state, then you're going to satisfy sufficient minimum contacts. But if it isn't, if it's not systematic and continuous, would it at least be foreseeable? The contact would, the defendant should understand, or it's foreseeable, but that their conduct would actually subject themselves to jurisdiction in that state. And then finally, would it be fair and reasonable to pull that defendant into the forum state? So that's sufficient minimum contacts. So does the defendant, again, have sufficient minimum contacts with the forum state such that jurisdiction or the exercise of jurisdiction wouldn't offend traditional notions of fair play and substantial justice? So using this kind of parameters, let's take a look at the hypothetical or the fact pattern that I gave you. So what do you think? Would the state of California be able to pull in the Oregon business, the individual who had the Oregon business, into the state of California? Take a moment to think about that. What do you think? So when you were thinking about it, can you think of, if you go through, so let's say the Oregon business owner's name is Dan, right? So Dan, can Dan be pulled into California? Let's give the student the name Samantha, right? So Samantha was injured. She bought the mask from Dan and then went to California, used the mask and was injured and filed a lawsuit in California. Can she pull Dan into the state of California? Dan is an out-of-state individual. The lawsuit is filed in California. So then, in order to exercise jurisdiction, they would have to prove that Dan had sufficient minimum contacts with the forum state, such that the exercise of jurisdiction doesn't offend constitutional due process and is fair and reasonable, in other words. So what do you think? What contacts, if any, does Dan have with the forum state? Did Dan direct sale or direct market to California? No. Did they advertise? Did they do any kind of services in the state? Did they solicit business in the state? Do they have regular and systematic contact? Does Dan have regular and systematic contact with California? The answer is no to all of those. So would it be foreseeable for Dan to defend a claim in California? Probably not. We can't find any sufficient minimum contacts with the forum state in this example to allow jurisdiction to be gained by this court in California. So Samantha would really need, and by law, lack of jurisdiction in California, she would need to file her lawsuit in the state of Oregon. Now, can you can you imagine if Dan? Can you imagine a circumstance wherein Dan would be subject to the jurisdiction of California? Well, yeah. What if Dan advertised in California? What if Dan had a sales outlet in California? Of course, if Dan had advertised in the state or had continuous regular business activity in the state of California, if he had a retail outlet in California, any of these things would allow California to gain jurisdiction. Beyond that, beyond this idea that the state's long-arm statute can bring him in, jurisdiction can be achieved by that state through personally serving the individual when they're present in the state. The defendant lives in that state, they're domiciled there, or the defendant consents to jurisdiction, so Dan could actually consent to jurisdiction as well. Now, one kind of extension or interesting kind of feature or factor of jurisdiction is an idea, and some of you might have thought of this yourself when you said, well, wait a second, the product itself went across the state lines, right? The product that he sold Samantha went from Oregon to California, and shouldn't that transfer jurisdiction to California because that product went from Oregon to California? And it's a good thought, and I like where you're going, but what we need to do is ask ourselves, how and what initiated the movement of that product across state lines? Did Dan purposely avail themselves of the privileges and benefits of conducting business in the state of California? In other words, did Dan produce that and then wholesale it out and then send it to California for sale? No. Did Dan even put that product in what we might refer to as the stream of commerce, with it ending up there in California, then being consumed in California? No, Dan did none of those things, right? And Dan, I'm still using that hypothetical, Dan selling the mask to Samantha in Oregon, and then she used it in California. So Dan didn't put that product in the stream of commerce, attempting or wanting for that to end up in California. So, because an argument that can be made is just that if an individual knows or tries to put a product in the stream of commerce with the goal of it getting to the state, or even the goal of just spreading that product to many different states, then they can't fall back on this, oh no, it wasn't foreseeable for me to be sued in that state, because they've tried to get it into the stream of commerce and it ended up in that state. Now that's much different than the plaintiff purchasing that product in Oregon and then unilaterally deciding to move that product from Oregon to California, consuming that product and then being injured, right? So this idea that the movement of the product itself by the plaintiff buying it in one state and then moving it by the unilateral decision across state lines, doesn't confer jurisdiction to that state. That being said, though, the stream of commerce test would suggest that if Dan, not the plaintiff, but the defendant, the business owner, if he had put that product in the stream of commerce and that product had ended up in distant states, we could argue that if it was foreseeable and an aim of that business was to get that product into different states, that they would be subject to the jurisdiction of that state. So one last question I have is, for example, if Samantha had bought the product in Oregon from Dan, same facts, Dan doesn't sell or market it to other states, it's just a local business, and then Samantha buys that mask and goes to California and let's say gives it to a friend of hers, who then gives it to a friend, the friend takes the mask and then flies to New York and then consumes the mask in New York and is injured. Is Dan going to go to New York to have to go to New York to defend the claim? So the answer you should be thinking is pretty easy, right? Dan, again, has no contacts with the forum state. In this example, one to California, then on to New York, the question still remains, does the defendant, Dan, have sufficient minimum contacts with the forum state so that the exercise of jurisdiction doesn't offend traditional notions of fair play and substantial justice? Here, Dan does not purposely avail himself of the privileges and benefits of conducting business in that state. It's not foreseeable. There's no connection between the forum state and Dan, and it's not fair nor reasonable. It's not there. It doesn't satisfy a due process analysis to force Dan to go to the state of California or New York, for that matter. Now, as things have changed, businesses have changed now that online presence is almost mandatory in many businesses, and so then you ask, well, how does the presence of a website change the analysis under the minimum contacts test? And it really doesn't, except to say that the test is the same, right? Does the minimum contacts, sufficient minimum contacts test suggest that the court look at the defendant and ask, does the defendant have sufficient minimum contacts with the forum state, right, before they exercise jurisdiction? Now, what the courts have done is said, well, this is more intriguing now, and we start to use kind of this sliding scale analysis, or the courts, I'll say the courts have done this sliding scale analysis, like what is enough contact based on a website. And what they've really kind of used is, some refer to it as the Zippo test, which came out of another case, and it says if it's a passive website, just providing information, usually not enough for jurisdiction to pass to all the states in which people can access that website. It's a passive informational website. Then on one extreme is a passive informational website. No jurisdiction is going to be conferred. On the other extreme of this kind of sliding scale is going to be a commercial website. Actively conducting business online, soliciting customers in the forum state, reaching out through emails and aggressive advertising through web-based advertising pop-ups and other things through social media and other things. That would confer jurisdiction. So then along this sliding scale is all those gray areas in between where the court is going to wrestle with the idea of, is it fair and reasonable? And does it violate due process to pull that defendant into the forum state, that distant forum state, based on their web presence? So that's it for this concept of in personam jurisdiction. And let me know if you have any questions about this. I appreciate you viewing this, and you can email me with questions, or you can attend one of the Zoom meetings, sessions, and ask questions related to this as well.